It will be a wonderful presentation with Justice Barroso and Mark Tushnet.
So hello everyone, thank you for coming. It's a pleasure to have all of you here. I'll briefly introduce our panelists so we can start. Our first panelist is Professor Mark Tushnet, a leading constitutional scholar in the United States, professor at Harvard Law School, who studies judicial activism in the US and around the world. And our second panelist is Luis Roberto Barroso, who is a leading constitutional scholar in Brazil, tenured professor of constitutional law at Rio de Janeiro State University, and currently serving as Supreme Court Justice in the Brazilian Supreme Court. So let's begin. Thank you for coming.
Should I start? Hello, everyone. It's a great pleasure to be here and share with you all some ideas and some thoughts on the roles of Supreme Courts in contemporary democracies. It's an honor to share this panel with my good friend, Mark Tushnet, who is, as you all know, an icon for global constitutionalism and a reference for everyone or anyone that has chosen law as a way to strive for a better world. So it's really a pleasure to be here. It's probably the third time we have this discussion. We always do it in English, which is very unfair for me, but that's the way it needs to be. I have divided my presentation in 5 brief chapters, very brief chapters, covering the following topics: the rise of the judicial branch in the world post-Second World War, the judicialization of life. Third chapter would be hard cases, complexity of modern life, and the creative role of courts. Fourth chapter, what factors influence a judicial decision. And the fifth chapter, the 3 different roles played by Supreme Courts. I'll be very brief about all of them. And I start with the rise of the judicial branch in the world post Second World War. Most authors agree that there are 3 main causes for this rise of the judiciary branch and constitutional courts in contemporary democracies. The first one is the perception that a strong and independent judiciary is very important to protect fundamental rights and to protect democracy. The second cause for this rise of the judiciary is a certain disillusionment with majoritarian politics. Congresses or parliaments at this point in most part of the world experience a moment of a certain loss of prestige. And the third reason for this ascent of courts is that regarding many issues, it's very difficult for parliaments to reach consensus in matters like abortion, gay marriage, assisted suicide, embryonic stem cell research. And so, since they cannot reach consensus, many of these matters end up being discussed in courts. In the case of Brazil, in case you were interested, I think there are 2 specific causes that made courts make them become protagonists in many matters. First, in first place, the Brazilian Constitution is a very comprehensive and detailed constitution that brings into law many issues that in most part of the world are left for politics. And the second reason why the Supreme Court in Brazil has become so visible and a protagonist in many matters, it is that because it's fairly easy to have access to the Supreme Court through direct actions. So this is what I would like to briefly cover about the rise of the judiciary. Along with this institutional ascent of the judiciary, what we see is a major judicialization of life. And we can talk about judicialization in a quantitative dimension and in a qualitative dimension. In a quantitative dimension, in most part of the world, the demand for judicial action has dramatically increased. In many parts of the world, the judiciary have become quite busy, and it actually has a certain degree of difficulty to deliver timely justice. So there is a quantitative issue that we're not going to discuss here. But just to give you an example, in Brazil right now, there are 70 million lawsuits currently going on, meaning that more than one out of every Brazilian adult is in court litigating at this point. So this is the quantitative dimension that we're not going to discuss here. What really attracts the attention of constitutional scholars is the qualitative dimension of judicialization. The fact that many important issues, political issues, social issues, economic issues, ethical issues, are having their last chapter before the judiciary and before the Supreme Courts, meaning kind of a transfer of power from the traditional political branches to the judiciary. This is a phenomenon that has been going on for a while throughout the world. And I did pick a few examples, starting with Brazil. It was the Supreme Court that established the procedure to be followed in the impeachment of the president. It was the Supreme Court that removed the Speaker of the House accused of corruption. It was the Supreme Court that paved the way for same-sex marriage. In the United States, it was the Supreme Court that decided the 2000 presidential election. The Supreme Court has endorsed a major interference with the prison system in California. It was the Supreme Court that also here opened the way for same-sex marriage. In Israel, it was the Israeli Supreme Court that decided that it was constitutional to build a wall separating the territories from Israel and Palestine. In South Korea, it was the Supreme Court that restored to his position a president that had been impeached. In South Africa, it was the Supreme Court that decided to strike down the death penalty. So I'm just citing a few examples how all over the world life and major issues relating to society has been judicialized. As it's easy to understand, all these examples represent that there is a lot of pressure at this moment in the border that separates law from politics. And the whole idea of separation of powers has been developing to accommodate this rise of the judiciary and the judicialization of life. I think we can all agree, and I think Mark and I will agree with this, that the conventional wisdom states that Supreme Courts have three major missions to play. The first one is to ensure the rule of majority, meaning that courts must defer to political decisions made by the other branches of government. The second mission of a Supreme Court is to protect the rules of the democratic game and thus prevent majorities from changing the rules to perpetuate themselves in power. And the third mission of a Supreme Court is to protect fundamental rights, including, of course, the rights of minorities. So one thing that I would like to stress here before moving on is the border between law and politics has become very blurry. But of course, there is a border. And that's an essential idea for rule of law. Law is different from politics. But what I want to say is quite often it's very difficult to separate clearly what is proper constitutional interpretation and what is the proper sphere for legislative choices. Well, this frontier becomes still more complex to define in modern complex societies when we're dealing with very hard cases which demand a creative role on the part of courts generally and of Supreme Court. So besides the rise of the judiciary and besides the judicialization of life, we have an increase of judicial discretion in the sense that in complex society, there's no way to preemptively solve all problems beforehand through black letter law, meaning that legislation many times delegate the power to decide cases to the courts. I'm going to cite a few unusual but real life cases that show this difficulty of law to foresee and to provide a ready-made solution for many of situations in life. First one, real case. Can a deaf-mute couple, through genetic engineering, choose to generate a deaf-mute child so that the child inhabits the same existential universe of their parents? That's a true issue that was brought for a court to decide. Another one, can a woman use the sperm of her dead husband frozen in a sperm bank to get pregnant? A third one, a real case that happened in Sao Paulo. There was a liver transplant line. A woman gets to the first place in the line and she gets the liver. And then a gentleman becomes the first one in line. When a new liver becomes available and it's going to be given to the gentleman, the woman that got the first liver has a transplant rejection. And then she claims the new liver. So you have a court case in which the judge will have to decide who gets the liver, meaning that he's playing God because he's going to decide who is going to live and who is not going to live. The point I'm trying to make here is that in many situations, you do not have a ready-made solution in law. And courts need to play a more creative role, and the only references are general clauses or vague principles, which of course increases the discretion of judges in deciding the cases. I cited some unusual cases, but this is kind of part of the routine of the Supreme Court, or at least of the Supreme Court where I work at. Just to mention three cases in which you had tensions between constitutional values without a pre-ready solution in the Constitution or in the law. First one, the building of 2 hydroelectric plants in the Amazon. a dispute that exposed the tension between national development and environmental protection. A second case that was discussed before the Supreme Court involving the publication of unauthorized biographies. And there you have a tension between freedom of expression and right of privacy. A third case, price control of healthcare plans, which involves a tension between free enterprise and consumers' protection. In all these cases, and this is the point I'm trying to make, the judge will have to find a solution and to construct a solution using subjectivity, using the facts of the case, and trying to demonstrate the itinerary he is taking to find the solution that is more adequate to the Constitution. So we have the rise of the judiciary, we have judicialization, and we have an increase of judicial discretion in the world we are living into. And of course, when you have a broader discretion of the judge, you lose a lot in objectivity, in legal safety, I would say. So moving on to my fourth chapter, what factors would we say that influence a judicial decision, especially when judges need to play this creative role we are here talking about? As we all know, there are two extremes in this matter of the creative role of the judge and relationship between law and politics. Legal formalism and legal realism. Of course, I'm oversimplifying it, but we don't have time to discuss this, and as it happens, the actual model is somewhere in between the extremes. But what I would like to briefly point out here are the factors that influence a judicial decision. There is a vast American literature on this, and I have divided these factors in three different models. The first one is what can be called the legalistic model, or the legalistic factors, which identifies this model, the influence that the Constitution, statutes, precedents, legal doctrines exercise when a judge decides a case. So we should stress at the outset that, of course, the legal materials play a very important role in any judicial decision, but not only the legal materials. So the second factor and the second model, the way I have systematized it, is what here in America they call the attitudinal model or ideological model that identifies the fact that judges are inevitably influenced by their worldviews, by their personal beliefs, by their point of observation of life. We're not talking about partisanship, but the judge, like all of us, like anyone, he has or she has an idea of what's good, of what is correct, of what is legitimate. And this is evidently projected consciously or unconsciously in his decision, in his work. So the second factor, besides the legal materials, is this attitudinal model or this ideologic chapter. And finally, the third set of factors that influence a judge in his decision is what we can call the institutional factors or the institutional model, which brings together factors that are external to the lawsuit, to the law, and to the subjectivity of the judge. When you decide a case, many times you need to take into consideration the relationship among the different branches of government. In the world we live, public opinion and the media play a fairly important role because we don't live outside of the world. We go to the barber shop or we go to the supermarket, and so you're within this world. And one other issue that a judge always takes into consideration when he decides something is the perspective of compliance with his decision. No one likes to render decisions that won't be followed. So there are also these institutional factors. So I would say we should consider these three models or three factors that influence a judicial decision. The legal materials, of course, the ideology of the judge, not in the political sense or a partisan sense, but in the sense of his idea of what's good, right, and legitimate, and those institutional factors that I just mentioned. So law is neither plain formalism nor plain politics, but a blend of legal materials, the judge's subjectivity, and institutional considerations. And here we get to the last part of my this presentation, which is the three different roles played by Supreme Courts or constitutional courts. I like, Mark, to divide everything in three. It's a superstition that I cultivate for reasons I don't have the time to explain. But there's this Nobel Prize winner, Niels Bohr, a man that worked with quantum mechanics, and he had a horseshoe by the door of his office in Denmark. And one day a journalist asked him why in the world he would have a horseshoe by his office, a man that was a scientist and agnostic. And he said, well, they say that it brings good luck even for those who don't believe. So the three roles played by Supreme Courts. The first one is very well known, is the obvious role, is the counter-majoritarian role, which is the role that's played when a Supreme Court invalidates an act of Congress, or for this matter, even an act of the executive, for being incompatible with the Constitution. This is, as we all know, one of the most studied subjects in constitutional theory, is an obsession here in America, as you probably know, since the first precedent that was Marbury versus Madison. But although Supreme Courts are known for this counter-majoritarian role, the interesting thing to point out here is that this is a role very rarely performed. Be it in Brazil, in Germany, or in the United States, a very low percentage of federal statutes are actually declared unconstitutional by Supreme Courts. And all surveys show that Supreme Courts all over the world tend to align themselves with the majorities. So this counter-majoritarian role, although it's very extensively studied, it's very rarely actually played. The second role I would like to highlight here is not very much studied by legal by constitutional scholars generally, which is what I call the representative role, which is a role that courts perform when they grant social demands that have not been timely satisfied by majoritarian politics. For many reasons, many times, legislatures move away from social sentiment. I won't have the time to explore these causes, but I want to make a terminological note here, especially in an audience where there are American lawyers, is that maybe the expression counter-majoritarian is not the proper expression here. Because if we admit that sometimes the courts can act in a more representative way than the legislature, what we can say when courts strike down an act of Congress is that it is counter-legislative or counter-congressional or counter-parliamentary, but not necessarily counter-majoritarian, because what I'm saying is that sometimes the sentiment of the majority is better interpreted by the courts than by Congress. That's one point I want to stress here, and I'll give you two examples, not sure, hoping that Mark will agree, in the American constitutional experience. First one, Griswold versus Connecticut. It's reasonable to assume that in 1965, at the height of the sexual revolution and the affirmation of the feminist movement, the prohibition of the use of contraceptives, even by married couples, did not correspond to the sentiment of the majority of the population, not even in Connecticut, where the case was discussed. So the decision of the court was representative in the sense that it was updating the social demand relating to contraceptives. Another example, Lawrence versus Texas, decided in 2003. So at the beginning of the 21st century, I think it's reasonable to say that the majority of the population did not think that intimate relations between gay men should be criminalized. So in both cases, the decision was not properly counter-majoritarian. It was more of a representative decision, kind of updating the law that the legislatures had not done. The same happened in Brazil when the courts have satisfied social demands that were not taken care properly by Congress. A famous case, I was a lawyer actually, the nepotism case. It was the Supreme Court that prohibited the appointment of relatives to public positions because Congress would not legislate on this matter. And it was the Supreme Court that struck down the law that governed electoral financing by companies in a way that did not preclude corruption, as all the recent scandals have demonstrated. So this is the second role, a representative role, when courts are the instrument for satisfying social demands that were not timely taken care of by the legislature. And the last role I want to mention here is what I call, in the lack of a better name, the enlightened role, which is a role that constitutional courts should play very exceptionally, because there is an authoritarian risk involved here. But it is a decisive role. It takes place when courts decide against the apparent will of the legislature and even against the will of the majority with the purpose of protecting fundamental rights, particularly of minorities, and of advancing history, of pushing history forward. This is an exceptional role that sometimes must be played by Supreme Courts. I'll give you a few American examples and then Brazilian examples, and then I'll close. First one, Brown versus Board of Education, the decision against segregation in public schools. I do know that there's some literature that says that maybe the majority of the population in the US supported or would support that decision. But the fact is that legislatures, especially in the South, would not approve that move for segregation. So if it were in the Supreme Court to do it, it wouldn't have happened. A second example of what I would call an enlightened decision was Lovin versus Virginia from 1967 that held unconstitutional a law that prohibited interracial marriage. And at that time, 16 southern states had anti-miscegenation laws prohibiting this kind of marriage. Third case, Roe versus Wade from 1973 that affirmed a woman's right to an abortion during the first trimester. And more recently, Obergefell versus Hodges that held that marriage was a fundamental right that could not be denied to same-sex couples. In all these examples I gave, legislature didn't pass a law. And at least in some of them, if not in all of them, it did not correspond to the will of the majority. But it was necessary to protect fundamental rights and to protect fundamental rights of minorities, to push history forward. So, exceptionally, with great parsimony, great caution, courts sometimes need to push history and bypass the will of majority and even the will of Congress. In Brazil, the examples are very clear. Gay marriage wouldn't have passed if it depended on legislature. The woman's right to an abortion wouldn't have passed if it depended on legislation. And there's a major issue going on involving the animal ethics Mark, which is, it was a decision of the Supreme Court that prohibited animals to be subject to cruelty in sporting events. And the court decided that vaquejada, it's a kind of rodeo, was unconstitutional. And there is a constitutional amendment trying to override the decision of the court. This is going to be up for discussion soon. But again, this animal ethics is something that is not in the mainstream of society, but I think it's an advancement that the court is helping to make. So these are the three roles: counter-majoritarian, we are used to it, representative, which happens quite often, and the enlightened role that courts play with great cautions, very rarely, but in decisive historical moments. So here I close. I read somewhere that George Washington made the shortest inaugural speech in the presidency of the United States with 130 words, and that William Harrison made the longest with over 8,000 words, pronounced in a very cold and stormy night in Washington, D.C. And from what I read, William Harrison died 30 days later from a pneumonia he caught that night. And I've always thought that that was the curse that befalls people that talk beyond their time. So I've been paying attention to that. So in this very quick presentation, I tried to address the rise of the judiciary and the constitutional courts, the judicialization of life and the difficulties in separating law and politics. I tried to highlight the fact that in complex societies, judicial discretion increases and that also empowers courts. I briefly mentioned the different factors that influence a judicial decision: legal materials, ideology, and institutional considerations. And I quickly mentioned the three roles I think Supreme Courts or constitutional courts play in contemporary democracies: counter-majoritarian, representative, and enlightened. Of course, whoever follows Brazil, just to say a word before closing about Brazil, we are talking here about constitutional jurisdiction. The Brazilian Supreme Court has been thrown in the storm of politics, not because of constitutional jurisdiction, but because of a jurisdiction it should not have, because no court has in the world, which is acting as a trial-level criminal court for politicians. That's what brought the court into this political storm Brazil is going on, with the fact that we are living a terrible reality show, which is there are over 500 criminal proceedings against politicians before the Supreme Court. So there's no way a court can deal with this without a permanent tension with Congress. So the tension between the Supreme Court and Congress is a product of a constitutional design, a mistaken constitutional design that brings to the Supreme Court a type of jurisdiction that it should not have, because if it plays well this criminal role, it creates tension with politicians. And if it doesn't play well, it creates tension with society. So it's a no-win situation that I've been trying, and more people have been trying, to change through constitutional interpretation to reduce as much as possible this privileged forum matter. So these are the basic ideas I would like to share. Constitutional courts should not be too shy. They should not be arrogant. No one should presume too much of him or herself. And I would like to end this brief presentation with a little parable I like to tell. And I think it's a good parable to illustrate how I see constitutional jurisdiction. In life, we are always trying to be in the right balance. It's true for people, it's true for institutions. In life, we're always trying to balance ourselves. Sometimes you move a little bit to one side, you move a little bit to the other side, but life is like walking in a tightrope. And no matter whether you are in the audience or you are on stage, sometimes people in the audience might think you're flying. And that's not a great problem, because life is made of some illusions. But the acrobat, which is all of us, we should know that we are balancing. Because if you think you're flying, you're going to fall. And in real life, there's no safety net. So I think constitutional jurisdiction, or judicial review, as the Americans prefer, and the powers of the Supreme Court should be exercised like life should be lived, with values, with the determination, with possible lightness, and with humility. Thank you very much.
So thank you for this terrific talk. I'm going to say four things very briefly and then pose one question to you, and then we'll see if we have time for some student participation. One of the things he's heard me say before. So the first point is for the U.S. students here, at least, I have to say it's an honor and a privilege to be on a panel with Justice Barroso. For the U.S. students, it's like you're having William Brennan in front of you, sort of this incredible figure in constitutional law. Second, this is what I have said in his presence before. There are very few jurists about whom you could say it would be scandalous if he had not been appointed to the Supreme Court. But it is true of Justice Barroso. It would have been a scandal had he not been. That's sort of not true of any of the justices of our Supreme Court. I mean, they're fine. It's not a criticism, but so and the third is as I think his talk indicates. It may well be the case that Justice Barroso is the most thoughtful and subtle sitting judge on a constitutional tribunal in the world today, and I think the talk suggested his identification of representativeness and the enlightened roles of judges is really important, both analytically and as something to be said by a constitutional judge himself. And then finally, this is just a minor point. The reference to Griswold in Connecticut reminds me of a great Philip Larkin poem, which I can't quote, but which begins something like, "Sexual intercourse began in 1963, just after the publication of Lady Chatterjee's Lover and before the Beatles' first album." so that's okay. So it's a great poem. It's a great poem. You should look it up. I wanted to ask a question, and it may be connected to your identification of the representative role of the court, about the, I think, uniquely Brazilian practice of public deliberation by the Supreme Court. Maybe, as I understand it, there are a couple of components of it, and it's only one of them that I really want to talk about. One is the court can convene a public, I think of it as a public hearing, in which issues are vented at the instance of the reporting judge. People come in and they testify about what they think the Constitution means, providing additional information and the like. But there's this other phenomenon, which is, as I understand it, in the ordinary case, the deliberations occur in public and on television, broadcast live. And if you could say something about how that affects the practice, what you think about it, I think it would be interesting.
Okay. Well, I can't take the compliments. I was very flattered, but of course, it's an exaggeration. There's a passage by Ortega y Gasset. Let me see if I can translate that. He says something like, between what you want to be and you can actually be goes the distance between the sublime and the ridiculous. So don't ever presume too much of yourself. That we have reminds me, Mark, of a story I read. I found it a lovely story about Picasso, the famous Spanish painter. He was living in Paris, and he didn't carry money on him. So whenever he had to pay a bill, he would get the napkin at the restaurant and make a quick drawing and would pay with it. And the manager would be so excited that he was getting that, an original by Picasso. And one day he needed groceries. So he took letter size sheet, and he made a drawing and had his maid go to the supermarket to bring whatever he needed. And then she brought he asked, and she brought a drawing, a strange drawing. And he asks the lady, "What in the world is this?" And the lady says, "Monsieur Pinault said that there was change." So the next day he goes see this guy who dared sending him a drawing. It's so pretentious that. So Picasso here is Mark Tushnet. I'm Monsieur Pinault. So don't take it wrong. About the public. I'll talk first about the easier one, which we can hold public hearings. I've been into a few as a lawyer, in a couple of them, one involving stem cell research, which was a very interesting discussion, and in which the Supreme Court, by 6-5, decided that it was constitutional to have embryonic stem cell research, which was a very interesting discussion, and to a certain extent it was here too, is whether you can use the frozen embryos that remain after in vitro fertilization to scientific research. It was a very interesting discussion. As a lawyer, I was also involved in a public hearing involving abortion in the case of non-viable fetus, the anencephalic fetus case. And as a judge, Mark, I held a public hearing on a very interesting case recently decided by the court. My opinion didn't prevail on the teaching of religion in public schools. And I convened a public hearing to which attended representatives of all religions. And I voted, and my opinion was that you cannot teach really confessional religion in public schools. So you can teach philosophy of religion, you can teach history of religions, but you cannot try to convert anyone to Catholicism or any other religion in a public school. As you probably know, there are many Brazilians here. The Catholic Church is a very powerful institution in Brazil. It's a real factor of power in the Ferdinand Lassalle's sense. And 6-5, my opinion did not prevail. So you can teach, you can have a priest or a rabbi or a pastor within the school, public schools and within the classroom in Brazil. Meaning that history is not linear. We go back and forth. You have to be prepared for that. About deliberating in public. Well, it's awkward, but it's good, and it's awkward in many senses. One of them is it's the only job, Mark. You tell your wife at home that you're going to work, and she can check on television if you're actually there. So it's and there are many problems or some problems associated with deliberating in public. One of them, of course, is it's more difficult to build consensus. When you're in privacy, you can say something, listen to something, and adjust. The way we work, you just give your opinion, and then somebody else gives his or hers, and then you kind of try to build a holding. That's one contribution I'm proud to say I brought to the court. Now, at the end of every judgment, we do deliberate what the holding is, because before, since you had every justice saying many times something different, you could at the end of the day, you would know if the motion was granted or not granted, but you wouldn't clearly know on what grounds. So now, whenever the judgment is close to an end, we vote a statement, meaning the holding, and that's going to be the binding decision. So this is good. But the problem is, it's more difficult to build consensus, and the opinions have become longer. I was the supervisor of a doctoral dissertation, Mark, that with empirical research showed that justices talk longer because they are on television, which is a mistake, because any TV director would say that on television, less is more. But this is a consequence. I want to point out, because this is very strange, I think except for Mexico, that also broadcasts the deliberation phase of the judgment. I think no other country in the world adopts this model. So I'm going to say why I think it has worked well for Brazil. In the first place, Brazil, like many countries in Latin America, the social imagination is that behind a closed door, there's something terrible going on. And it's often true. So the image of 11 members of the Supreme Court having studied the case, discussing the better solution in daylight is very good for the legitimacy of the court and for superseding any sort of suspicion that could be thought of. So I think this is good in countries where there is a tradition that the elites conspire against the people. If you can check what they're doing, it's good for the legitimacy of the work you're doing. So this is the first argument in favor of the broadcasting. The second is, it's interesting, again, if you know you're going to be on television, you go better prepared. You don't want to play a bad role on television. So I think the quality of the opinions and of the discussion has improved because of that. Third, there is kind of a didactic, I don't know if there's this word, like there's more participation of society in what's being decided by the courts. And the courts in Brazil have been decided very important issues. So it's a way that the civil society and population can kind of watch and control what's being done and elaborate their own opinion without the intermediation of the press. So, like in some cases or some discussions, when I read in the press what happened, I don't recognize what happened when I'm reading, because, of course, the press is an interpretation of the journalist. So the possibility that you actually see what's going on when important political decisions are being taken, I think it's also good. So I understand that this is strange, the broadcasting, public deliberation and broadcasting. I understand it's strange. But I would strongly argue in favor of it, Mark, because it has worked for Brazil. We have a fruit in Brazil that apparently there's only in Brazil called jabuticaba. And people like to say that if if you have it only in Brazil and it's not jabuticaba, there's probably something wrong with it. But I don't follow this idea. I think this is an innovation that did well for democracy in Brazil. It has its downsides. I must acknowledge that. One of them that you must be aware is not to become a populist judge, not to fall in love for public recognition, because many times, a judge has to decide against popular will. So what's constitutional and right, it's not always what is popular. And a judge must understand this and play his part following this obvious rule. But again, as I said at the beginning, constitutional courts tend to align themselves with the majorities. The counter-majoritarian rule is the exception. And what gives authority to a Supreme Court is its capacity of interpreting the sentiment of society and corresponding to it without being populist, but being able sometimes, but not too often, to say, I'm not doing what's popular because that's not what the Constitution says, and that's not what's right. But you won't see any court that has prestige that cannot interpret the sentiment of society. And part of the difficulties we face in Brazil right now is due to a criminal jurisdiction we should have, and when this criminal jurisdiction does not correspond to the social sentiment, that brings a stress in the relationship with society.
Thank you very much. I would like to thank our two panelists.
Thank you.